This series is dedicated to Daniel Webster, one of our nation's great, revered orators and public servants. Webster relied on the strength of his ideas to advance the American people's liberty and prosperity. He is rightly remembered as the great expounder and defender of our Constitution. For our resolution today, we ask, quote, do nationwide injunctions undermine the president's lawful authority? This debate is of great importance to our nation and its separation of powers system, especially given the upcoming Supreme Court arguments on the subject. We are humbled to that end to have such incredible speakers to discuss it. We are deeply honored to host the Honorable Chad Radler of the United States Court of Appeals for the Sixth Circuit as our esteemed moderator. To lead us off, we have Mr. John Malcolm, Vice President and Director of the Meese Center at the Heritage Foundation. To meet his challenge, we are thrilled to have Georgetown Law's very own Professor Steve Vladeck. Both Judge Radler and Professor Vladeck have participated in excellent Daniel Webster debates with us before. We are thrilled to welcome them back as friends of the series for such an important and timely discussion. We're deeply grateful to Federal Society and to Georgetown Law for making the Daniel Webster debate series a reality. I'll now introduce these three stellar panelists before turning the floor over to the brilliant Judge Radler. The Honorable Chad Radler serves as a judge on the United States Court of Appeals for the Sixth Circuit. Before taking his seat on the bench, Judge Radler served as Acting Assistant Attorney General for the Civil Division of the United States Department of Justice. He previously worked in the Columbus office of Jones Day, where he worked for 10 years as a partner in the firm's Issues and Appeals Practice Group. While at Jones Day, he appeared in state and federal trial and appellate courts around the country, most frequently the Supreme Court of Ohio and the Sixth Circuit. He also engaged in pro bono work, which included successfully arguing a case before the United States Supreme Court on behalf of an inmate claiming actual innocence, representing capital defendants in the 10th Circuit and the Supreme Court of Ohio, and even traveling to Nairobi, Kenya, with Lawyers Without Borders to train local lawyers in prosecuting domestic violence cases. Judge Radler earned his undergraduate and law degrees from the University of Michigan, and after graduating, he served as a law clerk to Judge Alan Norris of the United States Court of Appeals for the Sixth Circuit. Professor Steve Vladeck is a professor of law at the Georgetown University Law Center and is a nationally recognized expert on the federal courts, constitutional law, national security law, and military justice. Professor Vladeck joined the Georgetown Law faculty in July 2024 after spending the first 19 years of his academic career at the University of Miami Law School, American University Washington College of Law, and, most recently, the University of Texas School of Law. Professor Vladeck is the author of the New York Times bestselling book, The Shadow Docket: How the Supreme Court Uses Stealth Rulings to Amass Power and Undermine the Republic, which is a finalist for the 2024 American Bar Association Silver Gavel Award for Media and the Arts. He's argued over a dozen cases before the United States Supreme Court, the Texas Supreme Court, and various lower federal, civilian, and military courts, and has testified before numerous congressional committees, executive branch agencies, and the Texas legislature. A 2004 graduate of Yale Law School, Professor Vladeck clerked for the Honorable Marcia Berzon of the United States Court of Appeals for the Ninth Circuit and the Honorable Rosemary Barkett of the United States Court of Appeals for the 11th Circuit. He earned a BA summa cum laude with highest distinction in history and mathematics from Amherst College in 2001. Mr. John Malcolm oversees the Heritage Foundation's work to increase understanding of our Constitution and the rule of law as Vice President of the Institute for Constitutional Government, Director of the Meese Center for Legal and Judicial Studies, and the Ed and Sherry Gilbertson Senior Legal Fellow. In addition to his duties at Heritage, Malcolm is a past chairman of the Criminal Law Practice Group of the Federal Society and also serves on the Board of Trustees of the Washington National Opera and the Board of Directors of the Legal Services Corporation and the Barber Family Foundation. Before joining Heritage in 2012, Malcolm was general counsel at the United States Commission on International Religious Freedom, as well as a distinguished practitioner in residence at Pepperdine Law School. From 2004 to 2009, Mr. Malcolm was Executive Vice President and Director of Worldwide Anti-Piracy Operations for the Motion Picture Association. He served as a Deputy Assistant Attorney General in the Department of Justice's Criminal Division from 2001 to 2004, and was a founding partner in Atlanta law firm of Malcolm and Schroeder, LLP. Mr. Malcolm served as Assistant United States Attorney in Atlanta and also as an Associate Independent Counsel. He was honored with the Director's Award for Superior Performance for his incredible work as an Assistant United States Attorney in the successful prosecution of Walter Leroy Moody Jr., who assassinated an 11th Circuit judge and the head of the Savannah chapter of the NAACP. Malcolm began his career as a clerk to federal district court judge and a federal appellate court judge. He is a graduate of Harvard Law School and holds a bachelor's degree in economics from Columbia College. We're thrilled for this exciting discussion. Thank you all again. Enjoy the discussion. And Judge Radler, the floor is yours. Thank you.
Thank you, Brady, and thank you to the students who organized today's really terrific debate program. I think the semester is over, so as I mentioned to you earlier, perhaps this counts as extra credit, but you're going above and beyond. You had a great debate series over the course of the year. Thank you for doing that, and this is a really terrific way to cap the year. So I think everyone probably who's tuned in knows that tomorrow the Supreme Court will hear oral argument in 3 consolidated cases, sort of a special May sitting. And these cases on their merits address an executive order issued by President Trump addressing birthright citizenship. But I think everyone anticipates that tomorrow's arguments will really focus on the permissibility or legality of so-called nationwide injunctions. It'll be a contentious argument, and this is quite a contentious issue, so much so that we really can't agree on what we actually call the relief at issue. Some people use the term nationwide injunctions, some say national injunctions, universal injunctions. I've heard Justice Gorsuch use the phrase cosmic injunction. So the speakers can use whatever term they want. I think we'll all know what we're talking about, and I will make the point that I think we're not talking about statutory relief under the APA, which we're happy to discuss, but maybe that raises some different considerations than sort of seeking equitable relief in the form of an injunction and what the power of the courts are to issue those. I think Professor Sam Bray says that the first nationwide injunction was issued in the 1960s, but this is certainly in the last 10 years, this issue has gained steam. Maybe the first sort of most notable modern nationwide injunction came in litigation in the Fifth Circuit over the DAPA policy issued during the Obama administration. Then during the first Trump administration, there was a huge increase, I would say, in executive orders, quite a few in the Biden administration, and now we've had a number in just the first few months of the second Trump administration. I will admit one bias in that I lived through many of those nationwide injunctions during the first Trump administration. So at the time, I was the acting head of the Civil Division at the Department of Justice. When you're the head of a division at the Department, a litigating division, your name goes on every brief that comes out of the division. And so I suspect at the time, and perhaps currently, my name has been on more briefs as a government lawyer where the government has been enjoined nationally than any other lawyer in government history. Brian Boynton may have challenged that record last administration, and the folks now who are running the civil division at the department may well eclipse it. But I do have some experience with this. But I'll do my best to be a neutral moderator. I'm not too scarred by those, I guess you'd call them losses. But I will say that I suspect I speak on behalf of all federal judges and that we would certainly appreciate more direction from the Supreme Court. However, the Supreme Court resolves the issue. Hopefully they will resolve the issue to some extent through these cases. I think we'd all appreciate more direction so we have a better sense of what the rules would be on something that's sort of been an emerging issue over the last 10 years. And at this point, whatever your sort of worldviews are and views on different presidents, pretty much every president has experienced this over the last 20 years. And so everyone's kind of felt the brunt of nationwide injunctions for better or worse. So we're a pretty informed audience at this point. Let me then turn it over to our speakers. So I think it's really great to have both Steve and John here, friends of mine. John has agreed to go first. We're going to have maybe roughly 10 minutes of opening arguments, maybe a little rebuttal, and then I will ask some questions and we'll close out. So John, the floor is yours.
Great. Well, thank you. I want to first thank the Georgetown Federalist Society chapter, Georgetown Law, and Judge Radler and Steve Laddick for participating today. It's a pleasure to join you all. So the topic today, do nationwide injunctions undermine the president's lawful authority, I think really subsumes 2 issues. The first is, are there federal court judges that are impinging upon and thereby undermining the president's lawful authority? And the second is, if a federal court believes that the president is acting unlawfully, is a nationwide injunction an appropriate remedy? I will argue that the answer to the first question is yes, that there are some federal courts that are impinging on the president's lawful authority. and that the answer to the second question is no, that a nationwide injunction issued by a lower court judge is not an appropriate remedy, even if the judge believes that the president has acted unlawfully. After defining the scope of the problem, I will address the second question first. And my argument will boil down to essentially three main points: that nationwide injunctions are an extremely bad practice, that they violate existing Supreme Court precedent, and that they are unconstitutional. In terms of the scope of the problem, it's obviously been in the news a lot lately. There have been a lot of President Trump's executive orders that have been enjoined on a nationwide basis. I would note that nearly every one of these injunctions, although not all of them, have been issued by Democrat-appointed judges, and obviously they impact individuals far beyond the judge's district and involves, non-parties to the case. So according to a Harvard Law Review study between 1963 and 2023, there were 127 nationwide injunctions issued, the vast majority being after 2001. Over half of those injunctions, 64 to be precise, were entered against the first Trump administration. Over 92% of those injunctions were entered by Democrat-appointed judges. And in less than 4 months, there have already been close to 40 nationwide injunctions entered against the Trump administration, which is way more than the number of nationwide injunctions that were entered during all 4 years of the Biden administration. I would also note that in addition to the Supreme Court's argument in these 3 consolidated cases that will take place tomorrow, there's several proposals currently being floated in the halls of Congress by Senator Grassley and Senator Lee, Congressman Darrell Issa, that would attempt to address this issue legislatively by assigning randomly selected 3-judge panels whenever a request for a nationwide injunction is made, with a direct appeal to the Supreme Court. So my first argument is that nationwide injunctions are an extremely bad practice. First, the obvious. Nationwide injunctions by district court judges dramatically encourage and reward judge shopping. So, during Democrat administrations, conservative groups go to red states and try to seek out district court judges, and the opposite happens during Republican administrations with activist groups looking at blue states. And this helps to exacerbate the public's perception that judges are not really making decisions on the basis of law, that they're making the decisions based on their personal policy preferences. Nationwide injunctions means that a single federal district court judge, and there are 677 authorized district court judgeships in addition to all the other judges that are still on the bench serving, taking senior status, that enables a single federal district court judge to essentially usurp the power that can generally only be exercised by a majority of the justices on the Supreme Court, purporting to speak for the entire federal judiciary on an issue and threatening to hold someone who violates that injunction in contempt of court. Nationwide injunctions essentially give a single district court judge the power to effectively invalidate decisions by other district court judges across the country, or even appellate courts in other circuits that come to the opposite conclusion on an issue of law. Nationwide injunctions also effectively render class actions, certifying class actions under Rule 23 to be superfluous. Why bother going through the effort of certifying a nationwide class action when you could just declare a nationwide injunction on a go-forward basis without jumping through those hoops? It also means that any single district court judge can prevent a president from implementing a policy. And that means that in order to implement that policy, a president has to prevail in every single one of the cases. They have to run the table in every single one of the cases in which that policy is being challenged. Recognizing that a one and done approach to losses by the government that stifles lower court percolation. So you essentially don't have different judges being able to weigh different legal issues and come to different conclusions. The Supreme Court generally likes to hear the views of different judges, and both at the district court level and at the appellate level, before weighing in on issues. And it would also, by doing that, a one and done approach, it effectively prevents the federal government from relitigating these issues before another court. Giving preclusive effect to any loss that the government suffers in which a nationwide injunction is imposed would force the government to appeal virtually every case that it loses, even though it might prefer, based on the facts or circumstances, to wait until another case comes along before appealing the issue to a higher court. Injunctions are meant generally to guarantee that a prevailing party to a lawsuit can get the relief that he is seeking for past or ongoing harm. However, by granting prospective and prophylactic relief to non-parties, I would contend that single district court judges are effectively acting as a super legislature. It is the legislature's job to pass laws that establish prospective, prophylactic rules that apply to everyone, which is effectively what a nationwide injunction does. Giving power to judges in this way is not something I would contend that the framers of our Constitution ever envisioned or would have tolerated. My second argument is that nationwide injunctions violate Supreme Court precedent, and here I would cite to two different cases. The first is Baxter versus Parmigiano, a 1976 case in which the Supreme Court held that a district court abused its discretion by entering a judgment class-wide without having first certified a nationwide class action. Even more to the point is United States versus Mendoza in 1984, in which the court held that a judgment against the United States in one case would not have a preclusive effect. You could not use, offensive collateral estoppel against the government in a different lawsuit in which another party was challenging the exact same action. In that case, the court recognized that the United States is a unique litigant in that it is far more likely to be involved in a lot more lawsuits than any other private party. My third argument would be that nationwide injunctions are unconstitutional. In the absence of certifying a nationwide class action, judgments are supposed to be rendered in favor of parties when an actual case or controversy exists, not in favor of non-parties who have not filed a claim and for which there is no case or controversy as to them. The case or controversy requirement is supposed to apply to cases that are both in law and in equity. Injunctions are a form of equitable relief, and the Supreme Court has held on many occasions that equitable relief empowers judges to administer, and this is a quote from a 1999 case, a Scalia opinion, to administer in equity suits the principles of the system of judicial remedies administered by the English Court of Chancery at the time of our founding. Many of the injunctions that are being entered today cannot be reasonably traced back to practices that existed at the time of the founding through English courts of chancery. And this view about the limited scope of equitable relief has been expressed by a number of Supreme Court justices in the past. Now let me briefly answer the first question that I posed, which is, are there some district court judges through these nationwide injunctions that are impinging on presidential prerogatives? By entering these injunctions, you have unelected district court judges have essentially unilaterally determined that they can dictate national policy instead of a duly elected president. Injunctions are meant to preserve the status quo, which means in this case, keeping in place the policies that existed under the Biden administration and which were roundly rejected by the voters this past election. So I would contend that some of these opinions being issued by district court judges are essentially an attempt to undo the results of the last election. Under the guise of granting equitable relief, some district court judges have ordered the administration to spend billions of dollars in taxpayer money on programs that the president thinks are wasteful, not in the national interest, or in the case of funding, for instance, diversity, equity, and inclusion programs, outright illegal and unconstitutional. Additionally, as Justice Alito pointed out in a dissent from denial of certiorari recently, the administration is never going to be able to recoup these funds if its views ultimately prevail in court. Courts are making national security decisions as to who is fit to serve in our nation's military. They are also making national security decisions about which illegal immigrants and violent gang members can be deported. Such decisions have consequences about how a president conducts foreign policy. And when it comes to deciding national security issues, courts have far less expertise and knowledge than either the President of the United States or Congress, who get classified briefings, who get, sit in the National Security Council and get daily threat updates. Courts are making decisions about who the president can fire when it comes to getting rid of people whom the president does not believe are going to implement faithfully his policy priorities. And you also have, as a result of these cases, courts have been ignoring questions of standing and, in some cases, of their own jurisdiction. The Supreme Court recently said in the JGG case that if you have a beef in terms of you think you're owed money from the government, you're supposed to go to the Court of Federal Claims. If you're a government employee who believes you've been wrongly terminated, you are supposed to go to the Merit Systems Protection Board. There are in our nation's immigration statutes lots of statutes that limit the ability of district court judges to review decisions by immigration judges. All of those are being roundly ignored. Nationwide injunctions, to my mind, are an extreme example of judicial supremacy in which some of these judges are ignoring the co-equal rights of their co-equal branches of government to independently interpret the Constitution. Federal courts, by the way, this would include the Supreme Court, do not have supervisory power over the workings of the entire federal government. Indeed, the framers of our Constitution specifically rejected the idea of establishing a Council of Revisions, which existed under English law and in New York State under the New York Constitution. If had there been a Council of Revisions, then a group of judges would sit in judgment about laws that Congress had passed and actions that the president would undertake and would be able to reject them or revise them as they saw fit. The framers of our Constitution rejected doing that for good and sufficient reasons, and I think that that's what's going on here. With that, I'll stop and turn it over to Steve.
John, thank you very much. And Steve, it's great to have you back. I don't know if you've done a FedSoc program since the Lawyers Convention last fall, but especially if not, it's really great to have you back. Appreciate you engaging on the issue.
Yeah, the last program went differently. I appreciate the chance to be with you all today. I guess we'll save more of the response to John's last couple points for the end. So it seems like we ought to start with some context that I think was missing from John's opening remarks. So first is, if we're going to talk about an unprecedented number of nationwide injunctions, we should probably also talk about an unprecedented number of executive actions taken by the president in his first 16 weeks in office. The president has not been shy about this. He regularly touts the fact that he has signed more executive orders in his first 100 days than any president in history. It seems like we can't just talk about numerators. The denominator should also be part of this story. And so just making a claim about how many cases there have been or how many injunctions there have been without talking about how much the executive branch has done seems rather incomplete. Second, one of the points I'm going to come back to is the relationship between nationwide injunctions and nationwide class actions. Judge, you mentioned in your opening that there really is an uptick around 2013, 2014. I don't think it's a coincidence that that's almost the same time as the Supreme Court put much more rigid limits on certifying nationwide classes under Rule 23. And it seems like, that's a relevant data point as well, that these weren't just invented by, district judges in Texas to get the Obama administration, that it was actually trying to fill a gap that in some respects the Supreme Court itself had created. Third, John tried to analogize what's been happening in the last 3.5 months to what we saw during the Biden administration. I just have to suggest the data is rather decisively to the contrary. We have not seen the kind of judge shopping over the last 3.5 months that we saw during the Biden administration. We have not seen every single case brought to single judge divisions in Texas, at least as of last week. Right, we've seen rulings against President Trump from 70 different district judges appointed by 6 different presidents, sitting in 21 different district courts in 10 different circuits. That doesn't strike me as the same kind of behavior we saw over the last 4 years. And so I certainly agree that judge shopping actually exacerbates whatever one thinks the harms of nationwide injunctions are. I just think that we're seeing actually somewhat less of it right now. And also that in some respects, judge shopping may be the larger problem than nationwide injunctions. All right, so let me turn to sort of the relationship between nationwide injunctions and nationwide class actions, because it strikes me that virtually every single thing that John said in criticism of nationwide injunctions is a charge that could also be leveled against nationwide class actions. So for example, right, the notion that courts would be issuing relief that benefits non-parties. Well, even when you have certification, The Supreme Court has held over and over again that absent class members are not parties for many purposes. And so that seems like a data point that we should be talking about. Why is that okay, but not a nationwide injunction? Individual district judges obviously have the power to certify nationwide classes. They've done that for at least since 1966, when the current version of Rule 23 was adopted by the Supreme Court. Why is that power more appropriate than the power to issue equitable relief that's not plaintiff specific? Individual district court judges can issue injunctions benefiting nationwide classes. I mean, if you are able to persuade a district judge in San Francisco or Amarillo or Boston to certify a nationwide class and to issue equitable relief, then you have exactly the same effect. The government is similarly blocked on a nationwide basis by a single judge. You have relief that is benefiting non-parties, and you have the very real specter that one court in one part of the country is going to be thwarting a policy initiative adopted by a democratically elected president of either party. That's not to defend it. It's just to say that, well, then why is a nationwide injunction per se, in John's words, unconstitutional when nationwide classes are not? Now, it also seems like we ought to talk about part of how nationwide injunctions actually work. So, I'm actually rather taken by Justice Kavanaugh's concurrence last April in Labrador in the Idaho transgender medical care case, where one of his points I think is really important, which is that actually vertical stare decisis also ends up doing a lot of the work that a nationwide injunction does, where once the Supreme Court, for example, has weighed in a dispute, lower courts are at least effectively bound, even if they're not formally bound, in ways that are necessarily going to provide relief to non-parties, right? And we don't have a problem with that either. And so what we're really talking about at that point is just the sort of the short period of time between when the district court rules and when the Supreme Court rules, and whether district courts have the power to basically fix the status quo, right, within that period of time. Again, if the answer is yes for nationwide classes, it's not clear to me why the answer should be no for injunctions. Okay. The other piece of the story, and the other, I think, part of the conversation, is to consider the alternative. So a world without nationwide injunctions, a world in which federal courts were only allowed to issue relief that benefits the plaintiffs in that particular case. So let's start with the cases the Supreme Court's hearing tomorrow, the birthright citizenship cases. So in a world in which a federal court could only issue relief to individual named plaintiffs, in the Maryland case, for example, there are 5 named plaintiffs, and then there's CASA, which is an organization. Even assuming the Supreme Court sustains CASA's associational standing, and we know how Justice Thomas feels about associational standing, right? You'd still have relief dependent upon whether you were one of the 5 named plaintiffs or whether you can produce some proof of membership in CASA. And we might look at that and say, okay, fine, well, great. Well, so now you're in an emergency room and you've just delivered a baby to parents who appear to be covered by the president's executive order, that is to say, who are non-citizens, and the biological mother, right, is either here temporarily or is undocumented. If that's true, right, and if they're not one of the named plaintiffs, and if they're not a member of CASA, then you can't with Medicaid covered health care, right? You can't provide, like, for example, transplant services. There are various things the emergency room cannot do if the baby is in fact not a citizen and is undocumented, right? How are we going to enforce that? At a more holistic level, right? Are we really going to have whether someone is a citizen or not depend upon whether they're a member of CASA, or whether they're a plaintiff in Maryland versus a plaintiff in a lawsuit in Texas? Are we going to have different rules along the US-Mexico border depending upon whether you're in the 5th Circuit, the 10th Circuit, or the 9th Circuit? So there are also virtues here to nationwide injunctions that I think we don't play up enough. Virtues that I think are just as powerful prudential arguments in favor of this remedy in some cases, as most of John's arguments against them are, since again, I don't think the formal arguments actually hold up. And then there's the Alien Enemy Act litigation. Right, so we don't really have to speculate about what kind of difficulties lower courts might face in a world in which President Trump's policies could not be blocked on a nationwide basis in the Alien Enemy Act context. We know because the whole point of the Supreme Court's JGG ruling on April 7th was to close the door to nationwide relief under the Administrative Procedure Act and to require litigants to proceed through habeas petitions on a district-by-district basis. The result has been pretty darn chaotic. So I have a newsletter, I have an edition of my newsletter out this morning that tries to walk through the state of play. There are now different district courts that are in different states of play. One of those cases actually already has gone back up to the Supreme Court for additional emergency relief because of sort of, depending on your perspective, either efforts by the administration to subvert the JGG ruling or at least efforts to not aggressively comply with it with regard to detainees in the Northern District of Texas. And that's a context where you have just 7 district courts. There are 87 that are not affected because there are no immigration detainees in those districts. So again, like it seems to me that if we're going to make this about whether nationwide injunctions are wise or not, we ought to talk about all of the virtues that they serve and all the values that they bring, and not just the cost they impose. And let me just say, I mean, I say this as someone who is not super enthusiastic about nationwide injunctions. I testified before the Senate Judiciary Committee back in April, and was pretty clear that I think there have been too many of them during multiple administrations. But it seems like that's the right answer. The answer is to limit them, to require district judges to identify particular reasons why, for example, a nationwide injunction is necessary to provide complete relief to the plaintiffs, or why a nationwide injunction is necessary because a plaintiff-specific injunctionship cases. Like, I think it makes all the sense in the world to have a slightly higher bar for nationwide relief. But that is such a different claim than the claim that they are categorically beyond the power of federal courts simply because they benefit non-parties or they interfere with the power of the executive branch on a nationwide basis. There are plenty of other examples of relief that does both of those things. One last point on this, Judge Radler mentioned that we're not going to talk about vacatur under the APA. I'm grateful for that, except to note that it really doesn't make sense to me how you could have a constitutional objection to nationwide injunctions as opposed to a prudential one that wouldn't also render the APA unconstitutional insofar as it authorized nationwide relief. But we'll save that for the next Daniel Webster debate. All right, my last point before shutting up is, the last thing that John said is, I think, something that can't go unresponded to. So John has suggested that it's a usurpation of power for federal courts to order the executive branch to spend money, even when it's money that Congress has appropriated and required the executive branch to spend. John said it's a usurpation of power for federal courts to make decisions about who can or cannot be deported, even though in many of these cases, the claim is that these individuals have not received even the most basic due process before they've been put on a plane and disappeared into a Salvadoran prison. And it just seems to me that ultimately we have a constitution that empowers courts to require due process before people are removed from this country, to protect Congress's appropriations power, and to otherwise ensure that the president acts pursuant to law. We're not all going to agree on when the president is and is not acting pursuant to law. District courts are not going to agree with each other. Courts of appeals, I dare say, are not going to always agree with the district courts. The Supreme Court's not going to always agree with the circuit courts. But that's the system working the way it's supposed to. And it seems to me that trying to ratchet this up to some claim that there is a conspiracy among almost 100 federal district court judges spread across the country to prevent this administration and only this administration from exercising its lawful authority, I think is to really not give due credence to how hard these federal judges are working to handle what are very high stakes, high pressure cases unfolding on remarkably tight timelines. And so it seems to me that the bottom line is the formal arguments against nationwide injunctions prove too much. The prudential arguments against them fail to account for all of the ways in which they are useful. And the broader notion that courts are somehow acting inappropriately vis-a-vis this administration, I respectfully submit is wanting for evidence. Thank you very much.
Great, thank you. John, you might have a couple of points that you want to respond to. Happy to let you jump in and then go back to Steve, and then I'll ask a few questions.
Okay, thank you, Judge. I appreciate that. Let me respond to Steve's last point and then go back through about nationwide injunctions, which is one in terms of the spending amounts that Congress, it's true, appropriates money, and there will be a future fight, I am sure, about the constitutionality of the Empowerment Control Act of 1974. But in the meantime, Congress appropriates an amount of money which has to be spent over the course of the fiscal year, and in very few cases does it indicate when that money has to be spent and to which particular parties it has to go. And indeed, right now, with reconciliation going on, these budget discussions going on, there is a dialogue going on between the president and Congress about the propriety of some of these appropriations. And by a judge ordering at a particular time and to particular parties that billions of dollars go out the door, they are short-circuiting that discussion between the political branches and are granting a complete relief, not an equitable relief, to a party that will be impossible to recoup if the government ultimately prevails on its arguments. And I agree, of course, with Steve that even illegal immigrants are entitled to due process. I would point out, however, that removal proceedings are a civil proceeding. They're not criminal, and that all of these people are admittedly illegal immigrants. Whether they're gang members or not is a different story. Many of them have already been afforded due process in terms of the removal process and have had final orders of removal implemented for them. And that illegal immigrants have more limited due process rights, but that's a debate for another day. Steve points out, obviously correctly so, that the President Trump has made very aggressive use of executive orders. Those have all ramped up ever since Barack Obama declared that he had his phone and his pen and could bypass Congress with respect to the nation's immigration laws by trying to enact through an executive order the DACA program and the DAPA program. President Biden did exactly the same thing. It may not be, from a legislative perspective, the best way to run a railroad, but there's no reason why you should proceed in a different way than the normal course of litigation when parties challenge the propriety, legality, really, or constitutionality of those executive orders. Steve pointed out that there have been a number of different districts that have entered nationwide injunctions, including a few Republican appointees. That's true, but out of the, I believe, 39 nationwide injunctions that have been entered, 34 of them have been entered by only 5 districts. He points out that the same criticism can be made of nationwide injunctions. That single district court judges certainly have the ability to certify classes and then grant injunctive relief to those classes. That is true. We will see, depending on what the Supreme Court does, whether district courts start abusing their authority to certify nationwide classes, but at least there is a rule and standards by which to certify classes, and whether those standards have been met are appealable. He pointed out that there's the influence of vertical stare decisis. I, of course, recognize that. When the Supreme Court issues an opinion, lower courts are supposed to follow it. Within, Judge Radler in the Sixth Circuit, the states under the Sixth Circuit are supposed to follow what his court does. But that, once more, Steve makes the point, well, if a district court enters an order hinting at where they think the Supreme Court is or will be, that's an application of vertical stare decisis, and it will make its way up to the Supreme Court quickly. All of these cases, for the vast majority, they're not standing on clear precedents. These are largely cases of first impression. And as a result of nationwide injunctions, as I said before, it prevents percolation among different judges, and it ends up that on important issues, these cases end up getting expedited to the Supreme Court, where the Supreme Court all too often ends up addressing these issues through the shadow docket, which Steve decries for good and sufficient reasons. When there is a split, it's true that you can have different judges coming out with different rulings, and that's going to have equal protection arguments in terms of people and how laws apply to them in different jurisdictions. And it's usually the case that when you end up getting those sorts of splits, that those cases end up getting expedited, but there is still percolation by the lower courts before the Supreme Court decides to weigh in. Steve pointed out that nationwide injunctions are very efficient. That is certainly true. Our government is not always designed to be efficient. If we wanted to be efficient, we would allow courts to render advisory opinions. We would end up having the president be able to go to the Supreme Court and say, we're thinking about doing this. Give us your opinion about the constitutionality of that. That would be an incredibly efficient thing to do. it would also violate the Constitution because it would not arise within the context of a case or controversy. And I guess I would add, even though I think that because of this case or controversy requirement, some of the legislative proposals to create randomly assigned 3-judge panels with direct appeals to the Supreme Court, that might also have some problems too, but at least that would be a far more efficient solution. And because these 3-judge panels would be randomly selected, it would avoid judge shopping.
Hey, Steve, any further thoughts?
Just a couple, if I may. I mean, so first on John's response on class actions, where he says, well, at least there's a rule and there are standards. I mean, sure, but that's not remotely responsive to the notion that that proves that there's no constitutional objection. I mean, if the advisory committee with the Supreme Court's blessing can authorize nationwide relief once there's a certified class, it seems like the Constitution does in fact authorize nationwide relief. And then we're back to the prudential arguments. On the percolation issue, I'll just say, I mean, it's worth noting the Supreme Court is hearing oral argument tomorrow, not in one case, but in 3 cases, where you had rulings by 3 different district courts in 3 different circuits, where you had rulings by 3 different courts of appeals. And so it's not clear how nationwide injunctions prevent percolation. We had 3 different courts here, right? You know, John says nationwide injunctions put more pressure on the emergency docket. So I actually think this is probably why the Supreme Court is hearing oral argument tomorrow. I think there are justices who have probably become persuaded that the remarkable uptick in emergency applications they've received from the Trump administration would actually be somehow abated or at least slowed down without nationwide injunctions. And I'll just say that, like, all evidence is to the contrary. Again, in the Alien Enemy Act cases, the Supreme Court had to step back in 12 days after saying you couldn't have nationwide relief in the JGG case. That seems to be suggesting that, like, no, emergency relief is not like directly correlated to nationwide injunctions versus district-wide injunctions versus plaintiff-specific injunctions. John says judicial review short circuits the conversation between Congress and the executive branch, to which my response is yes, and sometimes the Constitution requires courts to do that. There are things that Congress and the executive branch can't do together. There are things Congress has done, like bar unilateral impoundment by the president, that courts should be able to enforce without waiting for Congress to say, we continue to believe this. And finally, and last, to John's point about removal proceedings, and that all of those individuals are admittedly illegal immigrants. First, that's actually not true. There are plenty of people in removal proceedings in the United States who actually were here in lawful status before they did something that made them removable. Second, and in any event, right, they have not all had the due process that the Constitution requires. I mean, in the case of Mr. Abrego Garcia, he was removed to El Salvador in the face of a withholding of removal that said he could not be removed to El Salvador. And so, you know, John sort of belittles my argument by saying it's about efficiency. Actually, my argument is about the ability of federal courts to meaningfully safeguard our constitutional rights and the separation of powers, both of which I think would be a lot harder, especially in this administration, in a world in which federal courts were limited to issuing relief that benefited only the plaintiffs in front of them. So that's, I think, a good place for me to wind up. Thanks again, Judge.
Sure. Maybe, John, I'll start with you with a question, or maybe I'll pick up on sort of the theme that I think Steve was alluding to. He mentioned it earlier and maybe alluding to there at the end. But, you know, one purported virtue, I suppose, of allowing district courts to order national relief is the uniformity that comes with it. Some people would think it'd be odd for individuals in Maryland, let's say, to be living under one set of rules because there's been a victory there, but then individuals living in Ohio or Michigan or somewhere else don't benefit from the same ruling. So if there's a federal action that's illegal or unconstitutional and a district judge calling balls and strikes, presumably, wants to enjoin that rule or that statute, the executive order, why shouldn't that rule apply uniformly across the country? Otherwise, we have sort of a patchwork then of rulings, and we have individuals being treated differently depending on which state or which circuit or which district they live in.
Well, that is the world in which we live in. I mean, you know, your circuit, when your court issues an opinion, is not necessarily bound by what the 11th Circuit does or what the First Circuit does. And when you end up getting those sorts of splits on issues of important national policy, that is when Congress, or more likely the Supreme Court, steps in. But then if you're going to sit there and say, well, we have 677 district court judges, and the one who issues an opinion first, a judge in New Hampshire, is going to issue opinions that are going to govern what a judges in Alaska and Hawaii would do, you end up having a race to the courthouse, a race to get out this opinion. And that first opinion, it will certainly apply uniformly. It will certainly be efficient. It may also be dead wrong and will prevent the government from relitigating these issues and a more calm and reflective mode of considering important legal issues.
Judge, can I just piggyback on that? I mean, so it seems to me that there's both some stuff I agree with in John's answer and some stuff I don't agree with, and it might help to crystallize our differences. Right? That yes, one judge will go first. But let's suppose that the judge in Alaska issues a nationwide injunction. That doesn't stop judges in other district courts from deciding the cases in front of them. It does not stop them from reaching a contrary conclusion on the same legal questions. It does not stop them from issuing a narrower injunction or no injunction at all. The difference is not about the judge. The difference is about the effect on the executive branch. And so, it seems like complaining about how this is affecting other judges actually rather misses the point. The question is, should one judge, whoever gets there first, right, be able to affect the executive branch on a nationwide basis? And there again, I think the nationwide class action is evidence of why the answer has historically been yes, albeit with limits. So, I don't think it's about shaping judicial behavior nearly as much as it is about shaping executive branch conduct.
Let me very briefly respond to that. I mean, I think that Steve is right. So, for instance, there was a judge yesterday that said that, I haven't read the opinion yet, that said the presidents can deport, the Tren de Aragua members invoking the Alien Enemies Act. Other judges have come to a contrary conclusion. So it's true that it affects the executive branch. But it does sit there and say, well, I'm a judge in New Hampshire. You did something in Hawaii that I didn't like, and I'm now going to haul you into court and hold you in contempt of court. It does tend to expedite, put a tremendous amount of pressure in order to implement a policy. Again, the president's got to he's got to run the table in every case that is litigated, and it ends up putting additional pressure to get the courts to act, particularly the Supreme Court, in a pell-mell fashion rather than in a more considered fashion, giving more courts a chance to weigh in on these issues.
Steve, let me take a question to you. So you addressed sort of the forum shopping point, and you maybe tried to disassociate the tie, but you did acknowledge that in the last administration, virtually all the cases challenging executive authority were filed somewhere in the Fifth Circuit. In this administration, you're right, there's more diversity, but the majority of the cases are probably in the DC Circuit. Always is going to get some of these cases, but otherwise the First and Fourth Circuits, maybe the Ninth Circuits, but they've been pretty concentrated in a handful of circuits. And one could say that because you can go sort of one-stop shopping, go to one judge in one presumably favorable district and favorable circuit and get nationwide relief, that does cut out a number of circuits across the country. I happen to sit in one where we don't, and this is not necessarily a vice, but we don't get a lot of requests. We don't get a lot of these cases. And so we sort of have two types of circuits these days. One, say the First, Fourth, Fifth, Ninth, DC, who have been getting these cases, and the rest of us who don't. And so some might think that's a sort of a criticism of nationwide injunctions and that we should prefer the sort of old world where cases percolate across circuits, we get different court rulings, and the Supreme Court has the benefit of all those thoughts.
So, I mean, Judge, I think I'm about as strong a critic of judge shopping as I think is known to man. And I think, without folks can debate till the cows come home, like, relative degrees of judge shopping behavior during different administrations. But if judge shopping is the problem, let's fix that. And so, as a case in point, the District of Massachusetts, where a number of these cases have been brought, shortly after President Trump came to office, the District of Massachusetts very quietly changed its case assignment policies so that any lawsuit seeking universal relief that was filed in the Worcester or Springfield divisions, the two one-judge divisions in that district court, had to go on the district-wide wheel. There are other reforms like that I think would be great to pursue, no matter what happens with nationwide injunctions. My concern is that we are sometimes treating nationwide injunctions as the boogeyman, when maybe it's actually the ability to manipulate where these cases are brought that's a larger problem. And I'll say one last point on that. There have been plenty of high-profile cases involving the Trump administration that have not sought universal relief. that have still been filed, Judge, in one of those same 4 circuits, right, that have still been the basis for emergency relief in the Supreme Court. And, that to me suggests that really what's going on here is not some massive referendum on nationwide injunctions, but rather just litigants doing what they can within the rules to bring the kind of relief they can bring. And I'm all for systemic neutral reforms that provide for more even distributions of these cases. But again, unless you have some, I don't mean you, Judge, unless there is some, broader, more coherent theory for why nationwide class actions are somehow on the right side of the coin, but nationwide injunctions aren't, it seems to me that most of these objections are not about the fact that the injunction benefits non-plaintiffs, but about something else. And we should talk about what those things are and how we can fix those.
If I could just very briefly respond, I certainly agree that judge shopping is a major problem. As I pointed out, 34 nationwide injunctions against the Trump administration have been entered out of 5 districts. So, that's pretty good evidence of judge shopping. I think that's also a reason why a majority at this point of the Supreme Court justices in either concurring opinions, dissents, or speeches have said that they think nationwide injunctions or cosmic injunctions, to quote Justice Gorsuch, are a bad thing, and that perhaps, as Justice Thomas stated an opinion, that they are legally and historically dubious, whereas I am in favor of getting rid of them full stop for the reasons that I've articulated. I agree with Steve that at the very least, if you're not going to say that this violates the Constitution in terms of not involving a case or controversy when non-parties are granted relief, that at the very least then the legislative proposals that are floating around Congress that would establish these randomly selected 3-judge panels with direct appeals to the Supreme Court would be a significant improvement.
So you've both mentioned efficiency, and maybe we can just tease that out a little bit more. Nationwide injunctions do lead to cases getting up to the Court of Appeals more quickly and to the Supreme Court more quickly. You both touched on this a little bit, but is that a good thing, a bad thing, sort of mixed consequences? But I think we'd all agree that nationwide injunctions are certainly expediting the process for review by higher courts.
I think in some cases it's a good thing, and in some cases it's a bad thing. So even under my way of viewing the world, if you ended up having lots of district courts or circuit courts having splits of opinion on important matters of national policy, that would get a case up to the Supreme Court pretty quickly, because the court would say, it's unfair, the way Steve put it, to have half the nation being governed by one set of rules and the other half of the nation being governed by another set of the rules. But at least then you have judges all across the country giving fulsome opinions as to why they think they're right and the other courts are wrong. So sometimes expedited review is a matter of necessity, other times less so.
I mean, I think if anything, that just proves my point, which is that this is not about nationwide injunctions. It's about other features of these cases. John and I might disagree about which cases warrant expedition and which cases don't. But I think once you sort of accept the principle that, sometimes it's appropriate and sometimes it's not, seems to me that the sort of the independent variable is not whether the injunction is non-plaintiff specific. Right. So, the Trump administration has filed 14 emergency applications in the Supreme Court so far. I think either 5 or 6 of them do not involve non-plaintiff specific, did not involve nationwide injunctions. And so again, I'm the last person who's going to say what we're seeing right now is signs of a healthy system. I actually think there's lots of reasons why we should be having a broader conversation about how to reform litigation against the federal government. Among other things, the difficulty of obtaining damages, I think, has pushed more pressure on injunctive relief in any form. But it just seems to me that, I don't know how you can look at the entire field of litigation against the Trump administration and walk away with the notion that the problem is universal relief, as opposed to something else. And again, if it's something else, let's fix the other things, right? If it's just courts responding to unprecedented lawlessness, maybe we should let them. But whatever the answer, it seems like this is a very interesting and strange single issue to pull out that's not going to solve the problems it will purportedly solve. It's not going to limit federal courts in the way that we think it would, and that I think would cause unintended and perhaps even intended mischief.
Let me just say one thing, which is that so Steve before during his opening remarks said, well, look at birthright citizenship. You have this executive order on birthright citizenship, and 3 circuits have weighed in on this. But the reality is that the way these cases are coming up is not because of the merits of the decisions that are being made. For the most part, in some cases they are, like the Tren de Aragua deportations. But usually it's a district court judge entering a temporary restraining order, and there's been a whole fights about whether temporary restraining orders can be appealable or not appealable, whether they're subject to mandamus. And then you end up getting preliminary injunctions, and all of the litigation ends up being about the propriety of entering a preliminary injunction. Almost all of these cases have not actually even had decisions on the merits of the underlying legal issues. And it's those issues that are very important that ought to get different judges considering them. I mean, all of these fights about how the case got there and whether it was appropriate to grant injunctive relief and how broad the injunctive relief, they are in a sense a distraction from the court getting to the main issue, which is what's the constitutionality of the actions at hand.
So, I mean, I agree with that. Again, I don't know what that has to do with the fact that the relief is not plaintiff specific. This was true in COVID cases where the Supreme Court very quickly decided in the context of applications for emergency relief from preliminary relief, whether state and federal COVID mitigation measures were permissible. This was true in the Biden student loan case, where the only court that had even tried to address the merits before the Supreme Court struck the program down was the 8th Circuit, which had devoted not one sentence, but one word to the merits, calling them, quote, substantial, unquote, in issuing a nationwide injunction pending appeal. And so, this is, again, a broader phenomenon in federal civil litigation that has been true both in cases with non-plaintiff facing injunctions and in cases with them. Or without them. And so, I think there are reasons why we're seeing so much more pressure on courts of appeals at earlier stages in litigation. We're seeing the Supreme Court step in at earlier stages. The Supreme Court doesn't review preliminary injunctions these days the way that it used to, which was for an abuse of discretion. Now it reviews them as if they're just merits decisions. And I've been critical of that when I've liked the answer, when I haven't liked the answer. I mean, again, these are structural phenomena that would be just as present if the injunctions that we're talking about just happen to be district-wide or to a nationwide class or even to a district-wide class or even just to a group of plaintiffs. I mean, had the district court in Amarillo blocked mifepristone access only within the Northern District of Texas, that still would have been an enormously important issue that would have gone quickly to the 5th Circuit and the Supreme Court, right? The fact that it was a nationwide injunction didn't change that. The fact that it was a nationwide injunction didn't make it more or less clear that the plaintiffs lacked standing, as the court would unanimously hold, right? And so I think we have a tendency to blame nationwide injunctions for lots of other things that I certainly agree are problematic, but that have, I think, less obvious solutions and messier solutions that require, I think, something more considered than just the Supreme Court ruling on an emergency application in the 3 birthright citizenship cases.
Sometimes percolation can be messy. I consider that a benefit, not a detriment.
But again, John, on percolation, you have 3 different district courts and 3 different courts of appeals who have weighed in on the birthright citizenship question. Like, how would that have been less? How would you have had more percolation in a world in which the injunctions in those 3 cases were plaintiff specific? Right? Some of the plaintiffs are like the state of California. I mean, there are 22 states are plaintiffs to one of those 3 cases. Like, what additional percolation would you have had without nationwide relief in those cases that you don't have here?
Well, you do raise an issue, which is sometimes you get these cases in which you say 22 states, and I take that as a given, have joined. And so that certainly expedites matters up to the Supreme Court, because you have 22 states saying one thing and 38 states saying another, but or 28 states saying another. My math is wrong first time around. But nonetheless, it's a different thing when you have individual plaintiffs who are sitting there and saying, the government's doing wrong by me. And without certifying a class, the court sits there and says, well, not only that, but I'm going to come up with a prophylactic rule that applies to everybody across the nation. That's what legislators do, not courts.
Let me jump back in. I do wonder whether you, even if you sort of think the rule is that courts should be understandably limited to granting relief to the parties in front of them, that plaintiffs are just getting more creative. If you have 10 or 12 states joining together in one lawsuit and they prevail, to afford to grant appropriate relief to 10 or 12 states might require a nationwide injunction. Same with a national organization and that kind of thing. So maybe we have to doff our cap a little bit to at least plaintiffs who are being more creative, even trying to work under what you might think the current rules are. Let me close with this. The arguments tomorrow. I'm not in the prediction business. I don't know if either of you are, but I'm happy to hear predictions. At a minimum, I'd love to hear what you think the court should say in resolving these cases. And maybe I'll throw in, is this something better addressed by statute? And either one of you can go first, but maybe those are a place we could close.
Steve, you want to go?
Sure. So I mean, I think let me start with what is a point I suspect of consensus among the three of us, which is, I think this is absolutely an opportunity for the Supreme Court to provide guidance, and guidance, no matter what the guidance is, I think would be useful, not just to judges like Judge Radler, but also to litigants and to policymakers. I think the House has passed a bill that would limit nationwide injunctions. I think that bill is a mistake for reasons I've testified about publicly. I don't think the Senate's going to pass that bill. I don't see it getting through a filibuster. Whether that should bear on the justices' deliberations, I think is something else entirely. But I guess the only thing I will say by way of prediction is the fact that the court is even holding an oral argument, and it's only the fourth oral argument the court's heard on an emergency application since 1971, is to me pretty powerful evidence that there are at least 4.5 justices who do want to at least consider the question of, if not eliminating, maybe reining in nationwide injunctions. And my real question, which I think tomorrow's argument will help to elucidate or shine some light on, or I hope it does, is whether anything that's happened in the 6 or 7 weeks since the court set these for argument might have changed those justices' minds. Right, that we've seen over the last 6 or 7 weeks, in my view, behavior by the Trump administration that shows exactly what the heightened costs of getting rid of nationwide relief would be. The ability of the Trump administration to move detainees, for example, from one district to the other in a way to try to get out from under TROs and preliminary injunctions in the Alien Enemy Act cases, I think is something that the justices are hopefully thinking about. But at the end of the day, what I really hope is that we don't walk out of tomorrow's argument thinking that how you feel about nationwide injunctions, one, should depend upon who the president is, or two, should actually sort of be the litmus test for how you feel about all of these trends in civil litigation. More cases where states are plaintiffs, more judge shopping, more forum shopping, faster, heightened stakes. I mean, those are all phenomena that won't go away without nationwide injunctions. What will go away is the ability of federal courts to quickly stop lawless behavior by any president on a nationwide as opposed to a far more localized basis. And it seems like at this point in American history, that would be a singularly bad moment to take that power away.
So I guess my remarks would be, as I said before, a majority of the justices, specifically Justices Thomas, Gorsuch, Alito, Kavanaugh, and Kagan, have either in opinions or speeches suggested that nationwide injunctions are illegal. And as you pointed out, Judge Radler, now both sides have had their ox gored on more than one occasion, although President Trump's the incision from the goring of President Trump's policies run far deeper than either President Obama or President Biden. Look, I think that the court there's chaos now in these lower courts with one district court judge sitting there and saying, I don't like a policy, even though I think some of these opinions impinge on presidential authority, and I'm going to enjoin it from being implemented nationwide, even though there are national security risks and all kinds of other risks for which judges have no expertise at all. I'm hoping and actually believe that it's likely that the Supreme Court is going to clean up the mess that's been created in the lower courts, and that they will uphold separation of powers, eventually reestablishing the preeminence of the political branches to establish national policy that's within their constitutional authority. And I also think the court is going to try to restore trust in the judiciary by having them address important questions of law in a considered fashion, by applying the law to the parties before them and only to the parties before them. But then, of course, we'll see what the court has to say, likely by the end of June.
Well, and once they do, maybe we can reconvene and hash out whether our expectations have been met. But let me just thank again both the panelists. This is a wonderful and very timely conversation. And Brady, thank you for convening the group, and I'll throw it back to you.
All right. Well, thank you everyone for a really outstanding, substantive, civil, and entertaining debate. To everyone who joined online, thank you so much for being part of the Daniel Webster debate series, and we look forward to seeing you next time. Thank you, everyone. Have a great day.
Bye.
All right. Thank you, everybody. I think we're good off the recording.
Thanks, guys.
This
That
was a
was
ton of
fun.
fun. That was really